Hello, thank you for joining me. My name is Lara Keenan. I am the Governance and Management Consultant for the Vermont Department of Libraries. And in this training video, I'm going to be talking about the laws that apply to public library trustees in Vermont. This is a brief overview, and if you have further questions, please feel free to reach out to me. We also have some resources on our website. So what laws govern your work as a library trustee? I like to point out first to Vermont State Statute Title 22, which is the statute in Vermont law that gives public library trustees their power. But before I dive into that a little deeper, I like to focus on this language, as always, at the beginning of my presentations, because it gives me goosebumps to think about the fact that the state legislature put it in state statute that public libraries are essential to the functioning of a democracy. And I love talking about that because it really puts into context the importance of the work that you do for your library and for your community. So as you think about the laws that apply to public library trustees, there are state laws, federal laws, perhaps some local laws, and the American Library Association guidelines and fundamental principles of librarianship. So as you can see just from the title of this slide, there is a wide range of laws and guidelines to follow, and it's important for library trustees to be aware of these. And in some cases, it's essential for them as employers to be aware of these to protect the library and the town, if you're a municipal library, from liability. It's also important to remember that running a library is similar to running a small business. You have employees, you have a building, you have a budget, and so the complexities inherent in that reflect the laws that you need to be aware of and to follow as a governing board member. There is a handout on our website called Trustee Training Laws That Govern Your Work. The link on this slide will lead you directly to it. It's a PDF, and in it, it has a couple pages of laws just to be aware of and links to information about those laws on government sites. So it's worth looking at that handout and just educating yourself as a new or a long-term library board trustee on the importance of the laws that apply to you and your work. In addition to laws, it's really important for library trustees to read and understand the American Library Association guidelines. And I have two specifically here, well, three actually. The Code of Ethics. The Library Code of Ethics is important for library trustees to read and understand because it does help guide the work of libraries, but also the Freedom to Read Statement and the Library Bill of Rights. These three documents together really are the philosophical foundation of librarianship, and it's important for library trustees as the ones responsible for creating policy for the library to understand these and make sure that you don't inadvertently violate any of them with the policies that you create for your library. Now, oftentimes I get questions about the division of power between library trustees and select boards, and it is natural for these questions to arise because of the way that libraries are set up in Vermont. But before I get into the division of powers, I always want to emphasize that it's really important to remember that we are all in this together. We all serve the same taxpayers and the same donors. And so it's important to remember that power struggles what might happen, but they need to be resolved in a way that tries not to be as divisive as they could be, so tries to smooth through personality conflicts while also being clear about each group's authority given to them by state law. So given that, there is a split. Select boards are used to having full power over what happens in their towns, and if you are a trustee in a municipal library, the select board may need to be educated over time about how Title 22 actually puts a separation between what the select board can do when it comes to the library. You, as a library trustee, have the power to, well, according to Title 22, if you're municipal, you have full power to manage the library. And if you're an incorporated public library trustee, you're on the governing board of a nonprofit corporation that has power. Now, the full power over governing that organization. Now, there may be some gray area in here depending upon the foundational documents of your library, depending upon any agreement you may have with the town. The library, the tax appropriation from the town may come with some strings attached, so it's important to know what the details might be. But in general, there is a separation between the libraries, who controls the library and who controls the town. And that's set up to really protect the library and protect the citizens' access to the information in the library. So the citizens know that the governing board of the town doesn't censor what they can access and doesn't see what they can access. Because if the citizenry doubts who doubts their privacy or protection of their privacy because they think that the governing board of the town is looking over the shoulder of the librarians and accessing who is taking out what, then the citizenry no longer has free access to that information. There is a psychological damage there. So this division of power is a delicate balance to maintain and nurture over time, because select board members change, library trustees change, and so you really have to work on maintaining that relationship, maintaining those good graces over time, so that everyone understands the clear separation of power and everyone understands the agreement that the library has with the town, whether you're an incorporated or a municipal library. Again, we're all in this together. So who's in charge when it comes to the library? And so it's important to know the library's sources of authority. So look at Title 22. The Secretary of State also created a publication, The Law of Public Libraries, which is on our website, which talks about various aspects of library governance and helps try to clarify who actually has authority over money, personnel, the building, that sort of thing. So that's what the second bullet point is. Become familiar with the Law of Public Libraries. Also keep in mind that our laws, the laws on the books, do not address every public or every possible scenario. So there are times when it's a very gray area and the laws aren't really clear, and you might approach me with a question and I might help you think through some of the implications, but I won't necessarily be able to give you a definitive answer. And so it's important to work together with select boards and other people in your community on behalf of your community and on behalf of the library. But also, when in doubt, consult your legal counsel. So if you are a municipal library, finding out who the lawyers for the town are and working out when you can consult with them. And if you're an incorporated public library, to have someone on retainer or someone that you could connect with to ask legal questions, to get real legal advice. Because as a state employee, I cannot give you legal advice. I can help you see some of the potential issues, but legal advice is not something I'm permitted to give. So you may not know what fiduciary means. I certainly didn't necessarily understand what it meant before I became a state employee. But as public library trustees, you do have some fiduciary duties. Basically, it means held in trust. So because you get public funds, because you get a tax appropriation, you have certain duties that you must maintain that have been upheld in Vermont court cases over the past 200 years. And so these really do apply to you whether you're municipal or incorporated. The first one is duty of care or diligence. So that basically means behaving in the best interests of the library and performing all of your duties in good faith. Again, as a trustee, you are really entrusted with the well-being of the library and expected to focus on the best interest of the library in all of your deliberations and all of your duties. The second one is duty of loyalty, and this is where conflict of interest comes in. Because you get taxpayer funds and donor funds, it is very important for the library trustees to avoid conflict of interest situations and avoid appearance of conflict of interest situations. And when they do come up, to really clearly address them in the board meeting and document that. However you want to address them as a board, they need to be talked about in the open so that no one doubts what you're doing with the money that is given to you. And conflict of interest relates to both personal and financial gain. So you want to make sure that no one doubts that that the money that you're entrusted with is going towards the library and not towards you as a trustee. And you want to make sure no one doubts that you're focused on the library and not on your own personal gain or the gain of anyone connected to you. And the last one is duty of obedience. So this involves understanding the state statutes, understanding the town's charter or your own library's charter, and then understanding the bylaws that the trustees set up for themselves and making sure that you follow all of these. So what laws should govern the trustee meetings? Well, first of all, if your bylaws stipulate following Robert's Rules of Order, you need to make sure that you do that. Of course, we don't require, it's not required in state statute that you follow Robert's Rules of Order, and I actually encourage you not to actually follow that. I encourage you to think about following parliamentary procedure, just because Robert's Rules of Order is very complex and it may be overly complex to follow it properly for a library trustee board. For municipal libraries, you are required to follow open meeting law for all of your meetings, and I will talk about that in a few minutes. If you are an incorporated public library, I strongly encourage you to follow open meeting law, and if you wish to meet Vermont's minimum standards for public libraries, you have to follow open meeting law. And then any norms or ground rules set by your board, you need to make sure that you follow. So when does open meeting law apply? Well, it applies whenever a quorum of the library board meets to discuss library business. Now, a quorum should be defined in your bylaws. Oftentimes it means a simple majority of seats on the board. And then whenever you come together to discuss library business, it needs to be an open meeting. So a quorum of library trustees can meet, but not talk about library business. And as long as you are disciplined about that and you don't swerve into talking about library business, you can have a private meeting. But once you start talking about library business, it needs to be following the rules set out in open meeting law. And the other point of open meeting law really is to give the public a fair and open opportunity. Well, this is the first point of open meeting law, to give the public an opportunity to participate in discussions that are being made by the government. And because you are using their money, their taxpayer appropriated money, you need to make sure that you allow folks to see what you're doing with that money and to participate in those discussions. But also, it's the other real point of open meeting law is to make government more transparent. You know, we are in a participatory democracy, so you need to allow that to happen. So what are the requirements of open meeting law? There are several of them, and this is just a list of them. And you can feel free to contact me with questions or contact the Secretary of State's office with questions. But basically, you need to provide advance notice of the meeting. You need to make sure that the public knows that you're going to meet. You need to make sure that they know what you're going to talk about at the meeting ahead of time. They need to know this. So you need to create and post an agenda. You need to conduct your business in an open meeting so that people can see what you're discussing and participate in that. You need to allow public comment at some point in your meeting. And then you need to record what happens in the meeting and post minutes. And open meeting law lets you know what needs to be in those minutes at a minimum. If there are any open meeting law violation complaints, you need to make sure that you respond to those, and the law itself tells you how to do that. If you have electronic participation in your meeting and a vote is not unanimous, then you need to do something called voting by roll call, which is where you record each person's vote individually as opposed to the overall vote. And then you need to follow executive session rules. So basically, you need to tell people you're going to meet. You need to allow people to know what you're meeting about. And then you need to tell people what you talked about. So what about agendas? Where do you post them and when? Well, for regular meetings, you need to post agendas at least 48 hours in advance. If you're having a special meeting, like if you don't get through all of your budget discussion in your regular meeting and you need to schedule a follow-up meeting, you need to post your agenda at least 24 hours in advance. And then if you have an emergency meeting, which should be very rare, you do not need to post an agenda, but this should only be for situations that require immediate attention. And then you should make sure you post about it as soon as possible afterwards, because these are meetings that have to happen imminently. Like if there's a flood at the library and you all need to gather to work on figuring out the solution, you don't need to worry about posting an agenda before you do that. The important thing is that you get to the library and figure out how to solve it. Where do you post them? Well, to follow open meeting law, you need to post them on a website that the public body designates. So that could be the town's website. It could be, usually it's the town's website. And if you're used to posting your agendas on your own website, hopefully your town can post a link to allow the public to figure out how to find your website and where the agendas are posted. They need to be posted at the municipal office. And then the municipality, the select board, has designated 2 other physical locations. And so you can talk to the town clerk or the select board to figure out where those other 2 locations are. What about the minutes? It's important to remember that library trustee board meeting minutes are public records, which means that they need to be available in perpetuity. So you cannot ever get rid of them. They always need to be located somewhere safe that the public can access. And they need to be made available within 5 calendar days of your meeting. So that's not business days, that's calendar days. What do they need to have on them? They need to have the names of all the board members that are present and any active participants. So if you have members of the public there that are active in the meeting with making comments, you need to record their names. You need to record all motions and proposals, resolutions, and the results of votes, so any official actions. And it's important to know that the law does not stipulate that you need to have a transcript as part of your meeting minutes. What you need is a true indication of the business of the meeting. That's what it says in the law. So summaries of points that were made, of counterpoints that were made, is all important, but you don't need a person-by-person transcript of who said what. Executive sessions, how do they work? Well, first, there are a series, they're listed out in open meeting law what you can officially go into executive session for. So I encourage you to look at Vermont's open meeting law to get that list of what you can actually use open meeting law for. It's not just anything you want. They're very specific things, like personnel issues is one of them. So to do open meeting law, first you need to make a motion. Officially make a motion, indicate which of those open meeting law statutory provisions you are using to go in, and indicate why you're going in. The board must vote on whether or not to go into executive session, and the vote must pass by the majority in order to enter. If the vote passes, the chair of the board asks the public to exit so that the board can have a private confidential session. But the board can invite certain people to stay who might be pertinent to the discussion. Once you're in executive session, you only discuss the issue that you went into executive session to discuss. Nothing else can be discussed. And you may not make any decisions inside executive session. You're just discussing the issue. And you're only discussing the subject matter of the motion. So you can't go off onto other topics. And then if the board wishes to make a decision based on the discussion, they need to end the executive session, reopen an open meeting, allow the public to come back in, and then vote outside of the meeting where the public can see the vote happen. Not every executive session will result in a vote, however. So the one thing about open meeting law is this unintended meeting, and they can happen. And so I encourage people to remember that if you're discussing problems and solutions and other library business with a quorum of members, you need to make sure that that only happens inside a properly warned open meeting. And when this can happen inadvertently is when people start a discussion with a quorum of members over email or over text, or even if you happen to run into each other socially. So it's important to be disciplined as trustees and remember the point of open meeting law is to allow the public to participate in these discussions. So if you have a quorum of you together and you're discussing library business, you need to make sure that it's part of a officially warned open meeting. Hopefully all of that made sense. Again, feel free to contact me with further questions or follow-up questions. You can email me or call me, and you can invite me to attend your trustee meetings. I would love to do any of that. And thank you for joining me.